Today's presentation is intended as general information only and does not carry the force of legal advice or opinion for any business's specific situation. Be sure to seek legal counsel or perform your own research concerning how matters discussed pertain to your specific situation before making any decisions related to your business. So Kevin is a partner with the law firm of Church, Hiddle, and Antrim. Before joining the firm in June of 2016, he served the Hoosiers for more than a decade as both the clerk of the Indiana Supreme Court, Court of Appeals, and Tax Court, and as the Supreme Court Administrator managing 28 employees. Before his government service, Kevin spent many years in private practice advising, not advertising. That's a completely different Kevin. Advising clients on a wide variety of labor and employment issues such as civil rights and discrimination claims, the Family and Medical Leave Act, as well as wage and hour compliance. And he continues to do so today. So Kevin, you want to go ahead and...
So on March 18th of this year, the president signed into law the Family's First Coronavirus Response Act, or it's called the FFCRA. Its purpose is to provide economic assistance to employees who have been prevented from working or teleworking due to the current pandemic. So technically speaking, the FFCRA is an act that's made up of several sub-acts, for lack of a better term. So today I'm going to talk about two of those sub-acts and how they affect employers. The first is the sub-act called the Emergency Paid Sick Leave Act, and the second is called the Emergency Family Medical Leave Expansion Act.
What actually does the Emergency Paid Sick Leave Act do?
Okay, so that's the first of the two acts. It requires all employers with fewer than 500 employees to provide up to 80 hours of paid sick leave to employees who cannot work or telework for their employer for one of 6 qualifying reasons. And I think you might have a slide on those 6 reasons. So if your employee is prevented from working or teleworking because he or she is subject to a federal, state, or local quarantine or isolation order related to COVID-19, that's the first reason. The employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. The person is experiencing symptoms of COVID-19 and is seeking medical advice or diagnosis. Number 4, the person is caring for an individual who's subject to the first or the second item we just mentioned above. The 5th exception or requirement is that the employee is caring for his or her own son or daughter because the child's school or place of childcare has closed due to the pandemic, or there's kind of a catch-all provision at the end that says the employee is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and Secretary of Labor. We do not know what that currently means at this time. We think it was put in there because if there's something else that comes up in this pandemic that's not specifically COVID-19, they want the ability to declare that someone unable to work because of that would fall within this Emergency Paid Sick Leave Act. But at this point, the first 5 reasons are the ones that are most important. That would allow someone up to 80 hours of paid sick leave.
The emergency order cause employees to qualify for the Act's paid sick leave under the first qualifying reason, or
okay.
What would it?
So Governor Holcomb has issued a series of emergency orders, the most recent being an extension of the state shelter-in-place order and declaring certain businesses essential and certain businesses non-essential. So the question of whether Governor Holcomb's emergency order would fall within that first of the 6 categories for why someone is unable to work or telework, it's kind of complicated. And the reason I say that is, remember that if the employee can telework, then no paid sick leave is available because the person not prevented from working. So just because you're ordered to shelter in place doesn't mean you qualify for paid sick leave if you can do telework from home, which a lot of us are doing, like most of the people in my law firm are doing. Second, if the employer's business is deemed an essential business under that order, and therefore the business remains open, then the employees of that business may not be considered to be prevented from working by the governor's order, since his order allows such employees to travel to and from work. And then third, if the employer's business is not deemed an essential business and the employer is closed entirely, then the reason that the employee is not working isn't because of he's prevented from doing so because of COVID-19, but because the business is closed. So there's a lot of questions as to who's going to fall under, if anybody's going to fall under that first order or that first exception about federal, state, or local quarantine order. Where I have seen it come up is where there's been local, certain cities that have said don't travel at all and have kind of gone above and beyond what the governor required. And I've heard from some of my clients that those people under that kind of an order have submitted that order to their employers saying, hey, I qualify under this first reason. And that client of ours has said, okay, and started giving that person their 80 hours of paid sick time. But a lot of people are probably going to fall under items 2, 3, 4, or 5 as opposed to number 1 at this point, just because number 1's a little loose in terms of how it would qualify, if that makes sense. The thing I would recommend for people who, for employers who have employees who are trying to ask for the paid sick leave under this first reason is make sure that you as the employer do in fact have work or telework for the employee to do, because if you don't, then the person's not entitled to work. That person, you need to lay that person off, and the person needs to seek unemployment because there is no work for the person to do. And then second, make sure that the general quarantine order or isolation order does in fact prevent the employee from doing the work or telework that you otherwise have for that person to do. Those are the 2 main things. And the reason that's important, and we'll kind of talk about this with all these reasons, is as we'll get to in a little bit, the federal government is also allowing a tax credit for employers that pay this paid sick leave out to their employees. And it's a tax credit on the Social Security withholdings that employers are supposed to take out of W-2 paychecks and then pay over to the federal government. That when the employers gather that money out of the paychecks, they can then, instead of sending off to the federal government, they can use that money as part of their tax credit immediately rather than waiting until next April to take advantage of it. But the reason it's important to make sure that your employees fall under one of these 6 reasons is because if you give somebody the paid sick leave and they really don't qualify for it, then you're being a real generous employer. But I'm not sure you're going to be able to then take advantage of the tax credit and get that money back from the federal government, if that makes sense. So if you want to be a socially conscious employer and not worry about getting paid back, that's wonderful if you've got the ability to do that. But if you want to make sure that you've got the ability to get this money back from the federal government in terms of the tax credit, then you really have to make sure that you are documenting why this person is gone, that you've got sufficient proof that the person is gone and prevented from working because of one of these reasons. And if you have that documentation, then you should be good if you get audited. But if you don't have that documentation, then you might get denied the credit.
So the next couple questions have to deal with like the second and third, actually even fourth one, the reasons. So the next one is, if an employee who self-quarantines because of concern, do they qualify for the paid sick leave under the second qualifying reason?
So that second qualifying reason, you have to show that you've been advised by a healthcare provider to self-quarantine because of COVID-19. And I apologize, we've got it as COVID-19, but that is, we do mean COVID-19 on our slide. And that's my fault for the typo. But the answer would be not unless the employee who is self-quarantining is doing so upon the specific advice from a healthcare provider based on that provider's belief that the particular employee either has COVID-19, may have COVID-19, or is particularly vulnerable to COVID-19. And keep in mind that the work that the employee performs must be such that she can't do it remotely while quarantined. If she can, then she doesn't qualify for the paid sick leave. And I'll try to hammer that home throughout today and repeat it. But in other words, you can't just decide, hey, you know what, I'm scared about COVID-19, I'm going to stay home. To qualify under that second reason, you have to have been advised by a healthcare provider that you need to stay home, not just I'm scared of bringing this into my home and infecting my family, or hey, I'm worried, I'm over 65 and I might be susceptible. You really need to have had a specific healthcare provider tell you that you need to stay home. Now, there's the question of whether the CDC whether their advice to people, let's say over 65, or people who are immunocompromised, whether the CDC's guidance would qualify. But if I was an employee, to be on the safe side, what I would do is I would call my doctor or go through some telemedic service that does some screening, describe my symptoms to them or my situation, and try to get something in writing from them saying, yeah, we think you should stay home. That would be probably a little stronger of evidence than just some general statement that was made in the newspaper to all people over the age of 65, or all people who had surgery in the last 3 months, or whatever someone else might say, generally speaking, if that makes sense.
So the next one is about the third qualifying reason. They want to know if an employee who's feeling ill and suspects that they have it, would they qualify under the third reason?
I'd say maybe. And that employee must be actively seeking a medical diagnosis, because that's, if you throw that slide up there again, Emily, you'll see that the requirement is that the person not only believes that she may have COVID-19, but she is actively seeking a medical diagnosis for that. And so this exception, if she qualifies under that exception, it would only apply up to the point where her healthcare provider makes the diagnosis. If the diagnosis comes back as negative for COVID-19, then the employee would not be entitled to any further paid sick leave under the Act, unless the healthcare provider instructs her to self-quarantine because she's at risk for contracting COVID-19 or some other reason related to COVID-19, which would then cause her to fall within the second exception at that point. In addition, keep in mind that the employee can only seek the paid sick leave under the third qualifying reason for the amount of time either that her symptoms prevent her from working or teleworking, or that she's spending time trying to get a medical diagnosis. In other words, like she's on the phone with the doctor, she's doing the online triage forms, filling out, she's traveling to the healthcare facility for appointment, that kind of thing. If she otherwise can work, then she's only entitled to pay sick leave for the time when that specific exception prevents her from working.
The next one is about the fourth reason. So this one is if the employee, can they qualify under the fourth reason if they're caring for anyone who falls under reasons 1 or 2, or are there any restrictions?
There are certain limitations. So the individual whom the employee is caring for must be an immediate family member, a roommate, or a similar person whom the employee has a relationship with that creates an expectation that the employee would in fact care for that person if he or she is self-quarantined or ordered quarantine. Additionally, the individual being cared for has to be obviously fitting within one of those first 2 categories. In other words, be subject to a federal, state, or local quarantine or isolation order, or have been advised by a healthcare provider to self-quarantine based on the belief that that person being cared for has the disease, may have it, or is particularly vulnerable to it. And finally, as always, the simple fact that you're caring for somebody at home doesn't necessarily, even if that person falls within all those categories, you're only entitled to seek paid leave to the extent that providing that care prevents you from working. So obviously, if you can only work at your employer's place of business and you have to be home 24/7 with this person, then you're going to qualify. But if you can telework, or if you only need to check in on that person a little bit, but you could still kind of come and go from work, then you really only should be taking the paid sick leave for the amount of time that you can't work because you're providing care for this person. Again, and similarly, if someone else can provide the care and you're not needed, then you really can't be seeking the leave because you aren't needed to provide that care, if that makes sense.
Does a person automatically qualify it under the paid sick leave for the fifth one if they have a child at home due to schools and daycares being closed?
I would say not automatically. The statute says that the employee must be prevented from working or teleworking because the employee has to care for that child whose school or daycare is closed. In other words, the employee has to actually be needed to provide and be providing care for the kids. If there's other suitable individuals that are able to provide that care, then the employee isn't entitled to the paid sick leave because he's not needed to provide that care. Similarly, let's say you've got an 8-year-old who can't be home by herself, but you've got a 17-year-old daughter who can. if the 17-year-old can care for the 8-year-old, then you aren't needed to be home, even though both kids are home from school. So you really have to be able to say to your employer in good conscience, I am needed to be home because my children's school is closed. And also something that's going to come up with this exception is the child has to be home because the school is closed related to COVID-19. So the period of time that would have been the kid's spring break and the kid would have been off school anyway, that doesn't count because that's not because of COVID-19, that's because of spring break. Those are some things to be thinking about. Similarly, for example, if your employee works Saturdays and Sundays, and that you aren't needed to be home to care for your child during those days because under this 5th exception, because the kid wasn't going to school on Saturdays and Sundays. So again, it has to be, you have to stay home to care for a child because that child is home from school and the school's closed related to COVID-19.
So if the employer doesn't have any work for them to do, and can the employees who fall under one or more of the 6 reasons above, can they receive the paid sick leave?
No. Okay. And that's something that we talked about a little bit earlier too. The paid sick leave under the Act is only available to employees who otherwise could perform their jobs for their employer, but for or because of one of the 6 qualifying reasons. So if an employer doesn't have any work, including telework for the employee to perform, then the employee's inability to work isn't because of one of the 6 qualifying reasons, but because there's a lack of work. So in that circumstance, the employee isn't entitled to paid sick leave and needs to seek unemployment insurance benefits instead.
Okay.
And we have a lot of people that are falling in that category because there's a lot of businesses that have either closed entirely or they've gone down to a skeleton crew and laid off some people. So to the extent that the person is laid off and not working, that person would qualify for unemployment, but wouldn't qualify for this paid sick leave under the Act. However, if the employer stays open and the person would otherwise be coming into work but can't because of one of these reasons, then that person would qualify for the paid sick leave.
Okay. The next one is from like an employer kind of view. How much do they have to pay them who takes the paid sick leave?
So it depends on of those 6 categories that we talked about and that are still up on the display. If the employee is taking off work because of reasons 1, 2, or 3, the employee is entitled to her full pay that she would have received up to a maximum of $511 per day, or $5,100 in the aggregate, because that would be, it's based on the idea of 10 work days in a work week or in the 80 hours. If the employee can't work because of the last 3 categories, so caring for an individual, caring for son or daughter, or that catch-all provision that none of us know what it really means yet, then you only get 2/3 pay, up to a maximum of $200 per day. The other thing to keep in mind is if you have your own paid sick leave policies available for your employees, with the employee's agreement, it has to be, the employee has to agree to this, but if the employee was entitled, for example, falls in one of those 2/3 categories, and then you wanted to do a top up for the other third based on the accrued sick leave that the employee already has under your normal policies, you can do that. You can't force the employee to do that, is my understanding, but you, with the employee's agreement, you can do that if that employee wants to receive full pay, but only qualifies for one of these 2/3 categories. But you have to, so if you guys, if the employee wants that done, then I would get in writing from the employee that the employee is asking that this be done, and then you could do that, and that will help you too, because you would only get the tax credit for the 2/3. You're obviously not going to get a tax credit for leave that you would have provided to the person anyway, because she already accrued it under your normal policies. But the benefit would be when all this is said and done and over with, you're not going to have then all this accrued sick leave under your normal policy that the person can now take on top of all this other leave that she just took because of COVID-19. So sometimes it's to the employer's benefit to have them run concurrently, that although you're paying them more money in the short term, it limits their ability to take that time off later in the long term. So you have, most employers are more concerned about having their employees at work than they are about paying them for time that they've already earned. You know what I mean? That's why sometimes it hurts employers to have somebody take 4 weeks of vacation and then come back and take 12 weeks of FMLA, because then they're gone 16 weeks and like, oh, I can't have this person gone all this time. So the same idea there. So give some thought to whether, if your employee qualifies for the 2/3 provision, but that employee has some accrued sick time that would also qualify for use, or vacation time or whatever, consider whether you want to offer them the opportunity to make up the difference with their accrued time, because that could benefit them by keeping them at full pay, and it could also benefit you by not having all this accrued time still hanging over their heads whenever we're finally able to go back to work.
So what if that's for full-time? What about part-time?
So rather than the 80 hours of emergency paid sick leave, part-time employees are entitled to the equivalent of what that person would have worked over a 2-week period. So if the part-time employee had a variable schedule, then how you calculate that is you would find the average number of hours per day that person was scheduled in the previous 6 months. And then you take that average number times 14, and that's the number of hours this person is entitled to. And then if the person didn't work at all during the previous 6 months, you use the reasonable expectation of hours per week or hours per day the person was going to work when the person was hired. Now, one thing that's important to keep in mind, and this is something that just came out recently in the regulations that the Department of Labor published, is that the DOL, the Department of Labor, is interpreting full-time for purposes of this act to mean employees who work regularly 40 or more hours per week. So some employers consider full-time workers to be those who are working 37.5-hour weeks. Such employees under the FFCRA would be considered part-time, and so they would only be entitled to 75 hours of paid sick leave under the act, not 80. Even though your own handbook may say we consider full-time to be 37.5 hours a week, 7.5 hours a day, for purposes of the act, those people would be considered part-time.
Person, if they already have paid time off or paid sick time policies, am I exempt from having to provide the paid sick time required by the Sick Leave Act?
Nope, unfortunately you're not. The Emergency Paid Sick Leave Act is on top of and in addition to whatever you already provide your employees in terms of vacation, PTO, or paid sick leave. And you can't force employees to use up their existing PTO or sick leave before utilizing the paid sick leave under the act. In fact, it's the opposite. The employees get to use their FFCRA paid sick leave first before they can be required to use any existing paid sick leave thereafter. Okay?
Okay.
So yeah, and those who have really, really generous PTO policies are going to be hurt harder under this act than those who don't have any PTO policies.
So what, the portion of it that's the FFCRA, what does that actually do?
You mean the Emergency Family Medical Leave
Yeah.
Expansion Act? Okay, so that's the second act I was going to talk about today. That expands the FMLA specifically to cover incidents where a worker can't work or telework because the employee has to care for a son or daughter whose place of care, school, daycare, whatever, has been closed because of a public health emergency, including COVID-19. So what normally happens with the FMLA is it only applies to employers that have 50 or more employees. This act expands the FMLA for this one particular reason, meaning school closings and daycare closings because of COVID-19. This applies to all employers that have fewer than 500. So even if you only have one employee, you're now covered by this small expanded portion of the FMLA. And if you have, so again, even though you have fewer than 50 employees, you're now covered by this FMLA expansion. There's an exemption for such employers that we'll get to a little bit in a few minutes. But at this present time, if you don't satisfy the requirements of the exemption, then you have to provide what we're going to talk about here in a minute under this expanded FMLA, which is separate from the Emergency Paid Sick Leave Act. There's some overlap, but it's separate. It's a separate act.
The Emergency Family Medical Leave Act, does it provide, let's see, what does it provide to eligible employees?
So it provides up to 12 weeks of job protected leave to employees who have to be home to care for a child whose daycare or school is closed, and the person can't telework. the care for this child prevents the person from working or teleworking. The first 2 weeks of that 12 weeks can be unpaid, although the employee must be permitted to use any accrued PTO or other paid leave that the employer would normally provide, or if the person obviously is going to qualify for the 2/3 pay provision of the Paid Sick Leave Act, because that's reason number 5 that we talked about earlier, and the slide is still up. So that's where the overlap happens. Those first 2 weeks of the 10 weeks, if the reason that you are off from work is because of qualifying reason number 5 under the Emergency Paid Sick Leave Act, then you can get pay during your first 2 weeks of the 12 weeks under this Emergency Family Medical Leave Act expansion. But the key thing is, normally employees don't qualify for FMLA. Even if their employers have 50 or more employees, the employees don't qualify unless they've been there for a year, and in the last 12 months before they need the leave, they worked at least 1,250 hours. Those requirements for this expanded FMLA are gone. All you have to be able to show as an employee in order to qualify is, 1, of course, your kid's home from school and you need to care for him, but 2, you've been employed by that employer for 30 days. That's it, as opposed to the 1 year and the 1,250.
Okay. The next question is, how are they going to pay for it? Like the employers.
Well, that's what a lot of people are asking these days. So we touched on this earlier. You can claim a tax credit for a dollar-for-dollar tax credit for the amount of money you pay out under of emergency paid sick leave. Again, it's going to be capped at $511 per employee per day who's off for reasons 1, 2, or 3. It's going to be capped at $200 per day for an employee who's off for reasons 4, 5, or 6. And you'll want to consult the IRS's website about how you go about taking advantage of this credit. And at the end of the broadcast, we'll have a URL that you'll see where you can go to get specific information from the IRS on this. But my understanding is you're going to be able to take advantage of that tax credit now. But I'm not a tax attorney, so don't quote me on that, and look at the IRS regulations and guidance that they provide with regard to that. A second way that you might be able to pay for this is there's a new thing called the CARES Act, C-A-R-E-S Act. And that's beyond the scope of what we're talking about today, but that provides a whole host of opportunities for small businesses to get loans, to pay for certain things, including payroll. And to some extent, some of that loan will be forgiven completely. So definitely look into the CARES Act. And the CARES Act is available even to sole proprietors who the owner is the only employee. And to some degree, it's available for nonprofits. So everybody should be looking in. If COVID-19 is going to impact your ability to make payroll, to make your mortgage payments, to make your rent payments, you need to look into that CARES Act to see what loans you might be entitled to and take advantage of those things too. So that's another way that you might be able to pay for this stuff.
Boy, you've got a lot of background on doing this recently, you can tell.
Yeah, and speaking of background, it's hard for me to look at this because I would really rather be in Northern California, Yosemite, than sitting here in Indiana.
Well, one day.
Yeah, someday maybe.
Okay, I think I've got.
So while Emily, while you're getting that up, I'll go ahead and start talking about what I think you're going to put up there, and that's
Okay.
If somebody, if a business, if the credits and the loans and everything still aren't going to be sufficient to keep the business afloat, what happens and what does the employer do? Well, and if they don't want to close their doors, because obviously it's always an option for an employer to just shut down and lay people off and close the doors, but some employers can't do that or don't want to do that for business reasons. And so employers who have 50 or fewer employees, they may be exempt from providing the leave that's required under the expanded FMLA exemption. So this doesn't, what I'm talking about now, my understanding is it doesn't apply to the Paid Sick Leave Act, except to the extent that the paid sick leave that you're taking is because your son or daughter's home from school and you have to stay home and care for her or him. So if you're staying home for reason number 5 and you're getting paid sick leave at the 2/3 rate because of that, then this would apply. But you can be exempt from the expanded FMLA provisions if you can show that the leave that you're giving people to take care of their kids because their kids are home from school would cause your expenses and financial obligations to exceed available business revenue and cause you to cease operating at a minimal capacity. That's one thing you can show. The other thing, second thing is the absence of the employer or employees requesting leave would pose a substantial risk to the financial health or operational capacity of the small employer because of that employee's specialized skills, knowledge of the business or responsibilities. So in other words, that person's a key employee. Or the employer can't find enough other workers who are able, willing, and qualified and who will be available at the time and place needed to perform the labor or services the employer or employees requesting leave would provide. In other words, you can't find replacements. And these labor or services are needed for the small employer to operate at a minimal capacity. So if you can show one of those three reasons, then you can be exempt from having to provide this up to 12 weeks of leave under the FMLA. And the thing to keep in mind, I mentioned there's two ways already. I mentioned that the FMLA is expanded for this one reason. One is it applies to a lot more employers, not just with those more than 50. It applies to a lot more employees because it's not just people that have been employed by the employer for a year and have worked 1,250 hours in the preceding 12 months. But the third thing it does in an unprecedented way is the FMLA has never ever required that the leave that is the 12 weeks of paid, the 12 weeks of leave be paid. It was just job protected, unpaid leave that an employee, if she had accrued PTO, could use during that paid leave on top of it. But the FMLA only ever required somebody to be allowed to be off of work without getting fired. It didn't require the employer to pay the person to be off from work. This is the first time that in this limited context, the federal government is ordering people to pay people to be off from work. So that the FMLA, the 10 weeks beyond those first 2 weeks of quote unquote unpaid leave, or if you take the paid leave under the Paid Leave Act, the next 10 weeks are paid at 2/3 the person's pay rate. Now, it's going to be questionable whether anybody's going to need to be off for the entire 12 weeks because the kids are home from school, because one, we talked about earlier, spring break hit in the middle of this, and two, schools, even though Governor Holcomb has stopped school for the remainder of the school year, I think an argument would be made that whatever before the epidemic, whatever that last day of school was going to be, you don't get any paid FMLA leave beyond that date because your kids were already going to be home for summer if you don't have year-round school. So whenever school was scheduled to pick up in the fall, if we're still not back in school yet, then I think this FMLA leave would kick back in at that point. But for that summer break, for those students who are at traditional schools that had a 3-month summer break or 2.5-month summer break, I think they would be hard pressed to be able to argue that the reason they're needing to stay home to care for their kid is because of the kid being home due to COVID-19 school closures when the school was already going to be closed for the summer anyway. So that's something that I think we'll see in the next few weeks or months as we get towards the end of May, beginning of June, and we see those dates come up where schools were already going to be closed. If I'm not sure that the employees will be entitled to this FMLA leave beyond that point, if that makes sense. Okay. And the other thing to keep in mind is if you are a small employer who has 50 or fewer employees and you want to take advantage of one of these exceptions, it has to be very well documented because you will get audited, and you can risk a lawsuit by somebody who says, hey, I was entitled to this leave, it wasn't provided to me, so they may file a claim with the Department of Labor and you might get investigated. You're gonna win that if you can prove it. But I guess my point is, don't be willy-nilly and saying, oh yeah, I qualify for that, I'm not going to extend this leave that the law requires. Make sure that you've made that determination and you've documented it, and then you keep those documents for at least 4 years, so that if you ever are audited or you ever are sued, you'll be able to prove that, yes, I did fall within one of these 3 exceptions.
Does the employer have to provide notice to the employees about the new requirements?
The answer is yes. And I'll just cut this short. The Department of Labor has put out a poster that you need to provide to your employees. If people are still coming into your place of business, you obviously need to slap that up on the bulletin board where you have all the other legally required postings like minimum wage, what to do if you get, the OSHA postings, all that stuff. So put it up there. If you got anybody teleworking, or my recommendation is you send that same one-page PDF poster to all of them via email, so you can say I satisfied my obligation to get them that notice that way. If you have a website with an employee portion that people log into to get personnel HR related information, I would probably put it there, or at least a link to it there as well. But definitely when you can get back in your building, you're going to need to print off the poster and put it up on your bulletin board. And then I would also, again, recommend emailing and websiting it at this time as well. And we will have a link at the end of our slides with that link to the DOL's website where you can get that poster. And one other thing to keep in mind, this leave is just like any other leave, whether it's the paid leave under the Act or the FMLA expanded leave. It's leave that the employee has to ask for and then justify the need for it. So there's a lot of forms that are being developed that if an employee wants to ask for the leave, that they fill this out and stuff like that. There's also requirements that the DOL has put out in terms of what information the employee has to provide to you. But again, it's just like any other leave. They have to ask for it. You're not obligated to just give it to them. But if your folks are already off, then you may want to reach out to them and say, hey, we're going to start applying this, but I need you to justify your reason for being home, because again, you want to cover your bases and make sure that you have all the documentation you need in order to get that tax credit at the end. If you're going to try to get paid back from the government for paying out this leave, you want to have that supported, and part of that support is going to need to be an affirmative representation from the employee that I can't work or telework because of one of these reasons. I think that's going to be enough. If you've got an employee saying, I promise you, I'm telling the truth, I can't work because of one of these reasons, then you're going to be good. But don't just assume that there's that good reason exists. You're going to want to have proof that it does, and the employee saying that it does and promising that I'm telling the truth that it does, that's probably going to be enough at this point.
What do the employees have to provide?
So any leave request, the bare minimum for all the leave requests, regardless of the reason, is obviously the employee's name, the date that the person is going to need to be off from work, the qualifying reason for the leave, and then an oral or written statement that the employee is unable to work because of that qualifying reason. And then, as you'll see on this slide, and then in addition, depending on what the qualifying reason is, there's a little bit more information that's needed. And you can just look through that. If it's because of the first reason, and in other words, a quarantine or isolation order, at a bare minimum, what's the name of the governmental entity that's issued the quarantine or isolation order, so the employer can then go verify that's true. An even better thing would be if the employee can provide a copy of it. But at a minimum, if the employee can't get a copy of it, he just needs to at least tell you what governmental entity issued it, so you can verify that. For the second reason, if you've been advised by a healthcare provider to self-quarantine, at a bare minimum, what's the name of the healthcare provider who gave you that advice? It would be great if you can get a written documentation from the, like sometimes we ask for return to work slips from doctors and stuff. Something like that says, yes, this person is under my care and needs to be off because of COVID-19. That's even better. But at this point, just at a bare minimum, you at least need to get the name of the healthcare provider. If you're off for the third reason, caring for somebody because of one or two, then whatever the reason was for you, or the qualifying justification or support for you, would be the same for that person, whether it's the name of the entity or the name of the healthcare provider. If it's the school closing reason, then you're going to need the name of the son or daughter, the name of the school place or child place of care that's closed, and a representation that a suitable person, that you're the only suitable person who can provide the care for the son or the daughter. And then if the DOL regulations don't have any specific requirements for that reason that says if you're experiencing COVID-19 and you're seeking a medical diagnosis, it doesn't, those regs don't specifically say that anything more is required other than the employee saying that that's what the reason is. But I think it would be fair for the employer to at least ask, okay, well, who's the doctor you're going to go see? And by when do you think you're going to be able to get that diagnosis, or at least get in to see that doctor, or do some kind of telemedicine thing to check, and then follow up with that person later to see if that person has done it. Because again, the person doesn't qualify under that reason if the person isn't actively seeking a medical diagnosis. I think it's perfectly fair and right for the employer to follow up and say, are you really seeking that medical diagnosis? What have you done to seek that medical diagnosis? Because at some point, somebody just simply saying, yes, I intend to do it, it becomes untrue if they never follow through. And if they never follow through, then they don't qualify under that reason, because you have to be seeking a medical diagnosis to qualify. And finally, the regs specifically say that an employer can also request an employee to provide any additional material that's needed to support the employer's request for a tax credit pursuant to the FFCRA. And the employer is not required to provide the leave if the employee does not provide the sufficient information that would justify the employer being able to get that tax credit. And so the DOL regulations cross-reference the IRS's website as to what the employer is going to need to show in order to qualify for the credit. And that's one of the URLs we're going to post at the end of the webinar, but definitely look that up, because again, I don't want to have any of your chamber members thinking, okay, I'm covered, I'm not going to shut my business down, I'm going to get this credit, I'm going to be okay, and then come up short and not be able to get the credit after they've already paid out all this money to their employers to take paid leave.
When do they have to start complying with the new requirements?
So the act became effective on April 1st. So you needed to start complying with it on April 1st. And let me just say that if you started providing employees with paid sick leave before April 1st, that doesn't count. That is either subject to your own policies, or if it was above and beyond what your own policies require or provide, then that was gratuitous. But you can't get credit for any leave that you provided prior to April 1. And if you closed your business prior to April 1st, and you laid off your employees, then those employees aren't entitled to leave, because the reason they can't work isn't because of any of these 6 qualifying reasons. The reason they can't work is because the business is closed.
Okay, so if they shut it down after April 1st entirely, or laid off a lot of employees and just kept a skeleton crew, like what happens then?
So after April 1st, again, once an employee is discharged or laid off, that employee is no longer entitled to the FMLA leave, expanded leave, or the paid sick leave. But the FFCRA is very clear that employers cannot discharge employees for taking the leave granted them under the Act. Therefore, an employer can close its doors or significantly reduce its workforce due to business-related reasons brought about by coronavirus. But it can't fire or lay off certain employees because it thinks those employees are going to be more likely to try to take advantage of the paid leave than others. And certainly, so you have to have well-documented reasons for why you are choosing employee A over employee B if you don't lay off your entire workforce, and make sure the reason isn't related to the pandemic. In other words, this employee has school kids, this employee doesn't. This employee is not going to be asking for paid sick leave probably, but this one is, so I'm going to let the one with the kids go. You can't do that. But if you close your business down, let's say on April 6th, then for that April 1 to April 5 period, anybody who asked for leave and qualified for leave, you'd have to provide them the paid leave. If they weren't out on paid leave prior to April 6th, and you close your business down April 6th, then there's nothing for you to provide because they were working.
Okay, so if they did go ahead and give paid leave to the employees and they don't qualify, fall within one of those reasons, what happens?
We touched on that a little bit earlier. You're not going to be able to get the tax credit. You're going to be at risk for not being able to get the tax credit. So that's why it's critical that you carefully document the reasons behind and the justifications for each employee being given the paid leave under the FFCRA. Now, you're likely not going to be tagged off base if your employee provides false information to you to justify his or her qualification for the paid leave. Now, that might be a terminable offense, but if a person says, for example, I needed to be home to care for my child because my child was home from school, and it turns out that the child was at grandma's the whole time, then that person probably could get fired for lying to you. You're not going to get tagged off base for giving that person leave if the reason you gave the leave is because the person submitted information that ended up being false to you, saying I was qualified for it. But if you don't get that information at the front end and you just say, hey, everybody who's got kids home from school, who are off from school, you're going to be given paid leave, and you didn't go through the steps of actually verifying that the person can't telework from home and has to be home to care for those kids and is the only person that can care for those kids, then you may not be able to get the credit.
The Americans with Disabilities Act, does it have any applications during this crisis?
To some extent. So we often think of the ADA as saying, and it does say, you can't fire somebody because they are disabled, and there's a certain definition of what disabled means, or you perceive them to be disabled, or they have a record of a disability. But there's a whole other part of the ADA that not many people think about, and that is again, the ADA only applies to people who have 15 or more employees. But it also restricts employer from making certain inquiries, medically related inquiries into the employee's health, and subjecting the employee to certain medical tests. So a question comes up of, well, if I see somebody at work and I think that person has COVID-19, what can I do? Can I send that person home? Can I make them can I take the temperature? Or is that an impermissible medical test or what? So I'll just go, we're out of time, so let me just go through these quickly. In a nutshell, you're not going to run afoul of the ADA or its provisions for following any CDC directives or governmental orders related to COVID-19. So when in doubt, you can follow the CDC or you can follow governmental orders relating to sending people home, whatever they say you can do. An employer can send employees home who are displaying COVID-19 symptoms. For employees that report to work feeling ill, who are calling sick, it is permissible for an employer to ask those employees questions about their symptoms to determine whether they have or may have COVID-19. Just keep in mind, if you do that there's a lot of overlap between the flu and allergies and COVID-19 in terms of, headache, sore throat, cough. Now I've heard certain discharges from the eye can be indicative of COVID-19 in some people, but so can watery eyes from allergies. So there's a lot of overlap, but one of the main things that I'm hearing that is a distinguishing feature is the chest issue, given that the virus attacks the lungs. So if you have employees that are saying, yeah, I'm feeling like somebody's sitting on my chest and I can't breathe, that's a real good indicator that maybe they've got it. And so, but just remember that whatever questions you ask to try to find out if this person needs to be sent home or not allowed to come into work because of the pandemic, you have to keep that information confidential. That still is another requirement of the ADA that remains in place, that whatever medically related information you garner from an employee, even though it's permissible for you to ask for that information now under this pandemic situation, you have to keep that information confidential. You can take an employee's temperature if she has a fever, but you got to keep that confidential. So anyway, you can find out if someone has COVID-19. Just keep that information confidential if you do, because again, that if you allow that person into your workplace, there's a potential of infecting others, and we can't have that because we have an obligation to provide safe workplaces for our employees.
Are there any other things that they should be thinking about related to the employees being off work because of it?
There's a whole host of things. Can't cover them all. But one thing to be thinking about that I think is the kind of the next wave of this is going to be employees who are members of the Reserve or the National Guard. If such employees are activated to help deal with COVID-19, which has occurred, it's at least occurred in Massachusetts. It's probably occurred in other states as well. One of my best friends in the world just got active. He's a surgeon with the Community Health Network and just got activated to go to New York to provide help. But if anybody gets activated to help out, it doesn't even have to be doctors. Obviously, it can be boots on the ground line employees who are reservists or National Guardsmen who are being deployed to distribute medical supplies or to whatever the president or the governor activates them for. Then the federal and state laws that deal with activated military employees all kick in, like USERRA. There's Indiana guidelines regarding that. And so if you have that happen, that's beyond the scope of what we're talking about today. My advice to you would be to follow whatever your guidelines, your policies say about reservists and National Guard activation. It's a pretty complicated area of the law. So don't tell that person, no, you can't go, because then you're going to get crosswise with the law. Let that person go, and then talk to your friendly neighborhood employment lawyer about any questions you have about what that means in terms of, what do I have to pay this person? How long can this person be gone? When the person comes back, what information do I need to get from him or her? How long do I have to keep his job open? Can the person use paid leave while he's activated? All that kind of stuff. Let the person go, figure out those answers to those questions afterwards, because obviously the most important thing is letting that person go do what the federal or state government has called them to do as part of a National Guard or Reserve. The other thing to keep in mind is if you provide health insurance benefits to your employees, sometimes some health plans allow employees to engage in what's called telemedicine, and actually have specific provisions about what is and isn't covered with telemedicine services. Telemedicine is where you either fill out an online form, or you have a virtual chat with a healthcare provider about your symptoms, or you do a Zoom thing like this and you talk to a healthcare provider in this kind of a way. There's some insurance plans that specifically allow for telemedicine services, or require you to, if you're going to do telemedicine, you have to do it through a service like Teledoc, TELEDOC. I would encourage our employers to talk to your insurance representatives, if you provide healthcare benefits to your employees, about whether the plan has anything in it about telemedicine. And if so, get that information to your employees, because the more that your employees can be taking advantage of those services and not going in to doctor's offices, the less likelihood of them getting sick, the less likelihood that if they are sick with the pandemic, spreading it to other people. And a lot of times the benefits, it helps with your premiums. It helps with the cost that you're providing to your employees if they take advantage of those telemedicine services. So I would say look into that, because that's a little known thing that we often don't think about outside the context of a pandemic. But if you've got that in your insurance policy, then take advantage of it. But the only way to find out, if you don't already know, is to talk to your claims rep or the agent that sold you your policy.
So the last thing is just all the places that we can get the links that you were talking about today. So I know Rachel's posted it on our website underneath the business assistance, right, Rachel? Is that where it's at? Okay. Yep.
And what I did was I highlighted in red that obviously I would recommend that people look at all these. But if you can only look at some, the ones in red are the most important ones. The first one, the DOL FAQ on the FFCRA generally, that's a very lengthy document, but it provides all kinds of information, a lot more information than we were able to get at today. The FFCRA poster is obviously one that you've got to have, and you've got to get posted in your place of business and sent out to your employees. And finally, those IRS guidance on seeking the tax credit, vitally important if you're to make sure that you're getting all the money from the federal government that you can, because after all, it is your money in the first place.
You know, this was really, really in depth, and thank you so much. I think the other day I heard on one of the chats that was going on about employment issues was that 501c3s and 501c6s fall into a different category. So for those people who are working for a non-for-profit, it looked a little different than those who were working for for-profit companies. Is that still the case?
What I've been seeing in terms of the FFCRA is not necessarily the case. I haven't seen anything in the act that exempts those people out, and so they would fall within the definition of an employer. For the Paid Sick Leave Act, do you employ one or more people? If you do, you qualify. Under the expanded FMLA Act, do you have less than 500? Have they worked for more than 30 days? That kind of thing. So there may be other aspects of things related to the pandemic that don't apply to nonprofits, but I personally haven't seen anything that says it doesn't, that what I've just talked about today doesn't apply to nonprofits. And I've actually seen some people commenting that it does. So if you are a nonprofit, I would definitely be asking those questions and doing your own research like we talked about at the beginning of this presentation. My goal here, and I think the Chamber's goal, is just to make Chamber members aware that this is out there. And this is kind of like blasting you, having you drink from a fire hose. There's a lot of information here. This wasn't designed to answer every single question. And again, it wasn't designed to provide legal advice. It's designed to get you aware that this is out there so that you go out and figure out, how does this affect me? How does this apply to me? Because unfortunately, when this whole thing started in March, I was talking to several Hamilton County people that were working for fairly large employers. I mean, very well-known businesses in our community that had, 100 employees. And I was talking to their high-level supervisory people, and they had no idea this was even out there. And so it just hit me that there's a lot of information here that there might be some people who just don't know. And it's not their fault. It's just, this is all coming at us. Every day's new. We're getting bombarded with information. It's easy for this kind of stuff to get lost in the shuffle. So I was, and the Chamber, we're both hoping to make our members aware of this so that they know where to start looking for more information if they think this might be applicable to them. But don't take this hour of conversation as being the end all be all, because again, there's tons more out there than just what we've been able to talk about today. But at least now you're on notice and you can start asking the right questions.
Thank you. We have a number of 501c3s and C6s in our chamber, and I just wanted to clarify that.
And have them specifically look at the CARES Act and the loans that are available under the CARES Act, because I think there's some specific discussion in there about nonprofits. And I know, for example, that I've got some friends that work for some ministries down in Southern Indiana, and I've been seeing those things come up in LinkedIn or seeing those articles come up, and I've been shooting them off to my friends down south, and they've been very thankful for me sending those things to them. So
yes. Thank you so much, Kevin. We really appreciate your participation. It's been fantastic.
You're very welcome. And if anybody needs any additional help, please call Church Hiddle and Antrim's main line. And we had, I think that was on the slide, but it's 317-773-2190. We've got a triage system in place for calls that come in with further questions about this stuff that we've talked about today. Just make sure that when you call in, tell the receptionist that you're calling in a result of the webinar that Kevin Smith did for the Zionsville Chamber, and then we'll try to get you with the information that you need within 24 hours if possible.